Thank you, Mr. President. I rise to speak on behalf of the Animal Justice Party in relation to the Right to Farm Bill 2019. This bill is what you get when good government is thrown out of the window in favour of performance politics and the protection of vested interests. The bill is a mishmash of provisions which seek to combine two populist concerns: prioritising the interests of agribusiness over everyone else in the community and demonising animal activists so that their genuine concerns about systemic animal cruelty can be dismissed. I would like to speak to the points that the Honourable Trevor Khan raised. It is not farmers, it is not the people who farm which the activists are targeting or concerned about. It is the practices, routine often practices, systemic practices that are part of farming, some of those practices which the activists document and take a photograph of and show the world. You may have your castle, you have a right to your castle, but your castle is not a fortress. And if there are activities which are occurring on your property, which are in question, which will no longer have a social licence, the community...
Order! I will call members to order. Every member has a right to be heard in this debate in silence. And can I remind honourable members that the Honourable Wall Second was on 2 calls, the Honourable Nat Ward is on 1 call, the Honourable Taylor Martin is on 1 call, and the Honourable Daniel Mookie is on 1 call. I don't want to start adding to the list.
Thank you, Mr. President. There is not one shred of evidence that any farmer has been interfered with directly or troubled or harassed or assaulted or harmed. There is not one shred of evidence that there has been a burglary, a door broken in, etc. All that these people have done is documented and published, and the world has seen what's going on. You could not get a better example as to the horse racing, as to what has happened in horse racing. All this has been going on for years. Where were the regulators? Who was taking the pictures lawfully? Who was gaining the evidence with permission? And I might point out to the Honourable Rod Roberts, it was a black woman who refused to give her seat to a young white man unlawfully, which caused a major change in that society. This bill is part of a playbook imported from America where animal activists have been charged and in some instances jailed for filming acts of egregious animal cruelty. Egregious animal cruelty. Fine for some people, it sounds. I would advise the government that it may regret bringing this bill on. You can't always guarantee the outcomes of what you want. The first Ag Gag bill in the United States was passed in Utah, and the first prosecution was against Amy Meyer, who stood outside an abattoir and filmed a clearly sick downer cow being picked up by a front-end loader, and taken into the slaughterhouse. Prosecutors charged Meyer with trespass and illegal filming, but within 24 hours it created such a public uproar that all charges were dropped. The slaughterhouse was exposed, not just for cruel treatment of an animal, but also raised legitimate concerns about public health. The Animal Justice Party condemns this bill as deeply flawed, unfair and unbalanced, and we will not be supporting its passage through this House. This bill is just another piece of Ag Gag theatre that does not address the core issue of why animal activists feel compelled to enter intensive facilities and abattoirs. They would prefer to be at the opera, seeing Beethoven's Seventh Symphony or a concert of Coldplay, rather than being compelled to go and expose what is being covered up and hidden. The government may claim that the bill protects farmers, but what they are seeking to protect is the wall of secrecy that prevents the public from learning the truth about the daily cruelties inherent in systemic animal production systems and slaughterhouses. We have seen successive ministers for primary industries so intent on spruiking the propaganda of intensive animal industries that any sense of justice or balancing of interests has been lost. In the words of the New South Wales Bar Association, the bill's penalties are, quote, harsh and disproportionate, unquote, given the nature of the offences. One has to ask why those trespassing to record evidence in animal cruelty face harsher penalties than those who commit animal cruelty offences. A maximum of 6 months jail for animal cruelty, yet a maximum of 3 years in jail for trespass. When the Minister for Primary Industries, Katrina Hodgkinson, labelled animal rights groups that covertly film animal facilities in order to expose animal cruelty as being, quote, akin to terrorist words that have been often used in this House tonight, she was tailoring her words to her audience, the New South Wales Farmers Association's annual conference. Instead of providing transparency and opening their farms to the public, the industry would rather criminalise whistleblowers. The current minister makes constant reference to, quote, vegan vigilantes, unquote. But what is a vigilante? The term was first used in the setting up of the vigilante committees in the United States. It was the name given to the citizenry that sought to combat lawlessness before the law arrived, or that took charge when the lawman failed. Given the abject failure of our animal welfare laws and enforcement agencies to protect animals, I think that is quite an apt description. Earlier this year, Minister Noel Blair accused animal activists of engaging in lawfare to prevent farmers from carrying out their usual farming activities, stating without evidence that, quote, complaints could end up in court where well-funded activists use legal tactics to drag out the process, making it unaffordable and unworkable for farmers, agricultural processors, fishers and foresters to do their job, unquote. The truth? Only 3 nuisance actions have been commenced in the courts in the last decade, and not a jot of evidence that they were launched by animal activists. It seems to me that this bill has exposed and highlighted an issue that I've been raising for more than 20 years and on many occasions during my time in the Parliament. The Minister for Primary Industries, or Agriculture as it is now called, has a number of responsibilities in his or her portfolio. They include not only agriculture, forestry and fisheries, but animal welfare. How can all this sit together? And maybe that is the nub of the issue. To have animal protection in the portfolio of a minister who is there to protect animal users/abusers does not fit. The portfolio of animal protection should be with the police and have nothing to do with businesses that use animals. Clear conflict of interest. Successive ministers have denied that there is an inherent conflict of interest in the oversight of both animal welfare and the profitability of animal industries. This bill is clearly designed to prevent the exposure of animal cruelty that is on a vast scale and often perfectly lawful. Cruel but lawful, that's the issue. Procedures such as debeaking, tail docking, mulesing, castration and eye teeth removal, all without anaesthesia and pain relief, would distress most members of the public, and videos certainly can't be found on the industry websites. The Aussie Farms documentary Dominion exposed horrors such as the suffering of pigs in gas chambers and the wholesale massacre of male chicks and the fate of spent dairy cows. None of this would be known to the public without the illegal installation of cameras by trespassing activists. I would doubt very much whether the owner and manager of a property would permit the installation of cameras so that their practices could be filmed. And if they're not doing that, doesn't it beg the question, why? Although the government has amended the bill to allay concerns from environmentalist and union activists about the bill's scope to draw in more than activist trespassers, it cannot remove fundamental concerns about the chilling effects of government acting in concert with industry to prevent exposure of systemic cruelty. As Amnesty International has stated about the US Ag Gag laws, What at first might appear to be exclusively an animal abuse issue is on closer inspection clearly also a freedom of expression issue, a workers' rights issue, an environmental issue and a public health issue, unquote. Sunshine, quote, sunshine, in our case the proverbial candle, really is the best disinfectant. We have no hope of stopping abuses if we can't even bring them to light, unquote. In Australia, we do not have the constitutional protections that are available in the United States for whistleblowers and for media reporting. We must rely upon the protections that were provided in the Lena Game Meats High Court decision. This was a case where I gave a videotape depicting the slaughter of possums in an abattoir in Tasmania. It was published illegally, and the ABC program published the illegally obtained footage showing animal cruelty at a slaughterhouse. At the High Court decision, Justice Kirby spoke of animal welfare issues as legitimate matters for public debate and noted the importance of public interest groups in raising awareness of these issues and of generating public debate in Australia, and that such debate has constitutional protections. Justice Kirby stated that, quote, within that democracy, concerns about animal welfare are clearly legitimate matters of public debate across the nation. Many advances in animal welfare have occurred only because of public debate and political pressure from special interest groups. The activities of such groups have sometimes pricked the conscience of human beings. Parliamentary democracies such as Australia operate effectively when they are stimulated by debate promoted by community groups. To be successful, such debate often requires media attention. Experience teaches that such topics change over time. In part, they do so because of general discussion in the mass media, not silencing, gagging, shutting down. Ag Gag laws, such as the Right to Farm Bill, make it even more difficult to obtain evidence in undercover investigation activities involving the exposure of cruelty in animal agriculture practices. This bill casts a wide net, criminalising anyone caught up in the investigation, thereby having a chilling effect on the journalists whose job it is to inform the public when wrongdoing has been exposed. One of the consequences of this ill-conceived war on animal activists is that this draconian legislation has been brought to the attention of a wide range of groups that ordinarily would have little interest in animal activists. In America, the campaign against Ag Gag laws helped build coalitions that had never existed before. Groups including Amnesty International, People for the Ethical Treatment of Animals, labour unions, the American Civil Liberties Union, and the Human Rights Watch, amongst others. I have stood next to meat workers' union employees in the fight against live export. We stood together on the same platform because their rights, their opportunities to employment were being struck down by the live export industry that also abuses animals. We stood together, and that was not a problem. In New South Wales, we have seen concerns raised by the New South Wales Council for Civil Liberties, New South Wales Bar Association, the Environment Defenders Office, Unions New South Wales, Greenpeace, and even the Meat Workers Union, as I described. In Ag Gag, they see a common enemy. When the history of the animal rights movement is written, the Right to Farm Bill will rightly be seen as being amongst the last desperate attempts of animal agriculture industries to conceal the ugly truth. The truth about the abject conditions in which animals are kept in intensive industries, the truth about the routine cruelties performed on all farmed animals, and the truth about the horrors of slaughterhouses. The truth will out.